Good morning, everyone, and welcome to this 39 Essex Chambers webinar on the implications of the current lockdown in England for those who need care and support and the people who are caring for them. I'm delighted to have so many people join us this morning for this very interesting and important topic. My name is Steve Broach, and I'm joined by my colleague Sian Davies, and we're going to split the talk between us this morning. I'm going to focus on the lockdown regulations themselves and look at the direct implications of the changes to the law on the way in which care and support can be provided, and those who have care and support needs can have those needs met. Sian's then going to look in more detail at the guidance that's come out, and there's been plenty of guidance on issues that relate to care and support. So there'll be a number of guidance documents that I'm sure Sian will want to go to this morning. We're going to go for about an hour and a half until 12:30. And I should stress that the session is being recorded. We were overwhelmed with interest in today's talk, which was great, but unfortunately it's meant that a number of people who wanted to attend haven't been able to. So we will be recording the session, and that's part of the reason why questions will be dealt with anonymously. So please do put questions in the Q&A box at the bottom of the talk, and please do try and make them general questions. Please don't ask questions about your particular case if you have one. Please try and make them as general as you can so they're of wide interest. And please also keep them short, because we're going to be trying to filter them as we go through, and we won't have time to read long questions and then answer them, of course. That's our main speaker request. So we will be recording the session. That means, of course, you'll be able to pick up Sian's slides, and also I'm about to share a copy of the regulations themselves. So we hope that this will be a useful resource that will be available on the 39 Essex Chambers website and will be emailed around to those whose email addresses we have as well. So without further ado, I'm now going to share my screen, checking I've closed down everything sensitive. And what should come up, all being well, is the regulations. Now, for those who aren't lawyers joining the talk today, this looks somewhat intimidating, I accept. The Health Protection Coronavirus Restrictions England #4 regulations from 2020. So these are the lockdown rules. And there's a key distinction to be drawn between regulations and guidance. Guidance is what the government would like us to do, what it thinks would be a good idea. The regulations are the law that requires us to behave or not behave in certain ways. And I think it's very important that we focus on the wording of the regulations themselves and don't just look at the guidance, because the guidance can sometimes be wrong. For example, during the first lockdown back in the spring, the guidance said that everyone had to only leave their homes once a day for exercise, whereas in fact the regulations said no such thing, and that was then challenged. The guidance was challenged successfully and amended to reflect the fact that some disabled people would need to leave home more frequently to maintain a good standard of health. So that's why I say we should be starting and perhaps even ending with the regulations in terms of understanding what the legal requirements are. And you'll see as I scroll down that the regulations are in various parts. And the two parts that I'm going to focus on this morning are part 2, the restrictions on movement, and part 3, the restrictions on gatherings. Now, there are also, of course, important restrictions on businesses, whether they can open at all or in part, whether they have to close. And then there are the enforcement provisions. As we know, these regulations are backed by criminal sanctions, but I'm going to assume for present purposes that what we're focusing on is what we can and can't do, not what will happen if we do the wrong thing. So that the focus of the short time available today will be on parts 2 and 3, the restrictions on movement and the restrictions on gatherings. And so we start with regulation 5, which is the restriction on leaving home. And it says very clearly that no person may leave or be outside of the place where they are living without reasonable excuse. So that's the test that has to be applied, is do you have a reasonable excuse to leave your home? And you'll see then in 5.2 that for the purposes of 5.1, this prohibition on leaving the home, the circumstances in which you have a reasonable excuse include where one of the exceptions set out in Regulation 6 applies. There's no definition of what what your home includes, and an exclusion of people who are homeless. But what's important here is that these exceptions in Regulation 6 are not a complete list of reasonable excuses. There could be other reasonable excuses for leaving the home. So on the question of leaving the home, you don't have to come within one of the exceptions in Regulation 6, although clearly, to avoid any doubt, to avoid any question of being challenged, or at least if you are challenged to have a clear reasonable excuse, it will be much better if you can come within one of the exceptions set out within Regulation 6. So let's have a look at those. These are the exceptions referred to in Regulation 5. And so the first, exception 1, is some specified purposes for which it is accepted to be necessary to leave the home. The test here is whether it's reasonably necessary. So you come with an exception 1 if it's reasonably necessary, which means that you have a broad degree of judgment there, for you to leave the home, to buy goods or obtain services from any of the businesses that are allowed to stay open for themselves or your household, vulnerable persons generally, or persons in the same household as a vulnerable person. So if you need to go to the shops, in essence, to go to banks, to take exercise. So this is important because, of course, this was controversial last time. So it's reasonably necessary for you to leave the home to take exercise. Of course, that means you can't excessively leave the home to take exercise. And if you've been out for your 17th jog that day, you may well struggle to defend the challenge that you have left the home unreasonably in that context. But if you're leaving it on a reasonable way, if you're taking a reasonable degree of exercise, you can leave the home either alone or, importantly, with one or more members of your household or your linked household. Now, we'll need to come to what that means in a little while. Essentially, it means the support bubble, as people will know, or where one of them is a child, one of the people is a child under 13, a member of your linked childcare household, which is the childcare support bubble. Or all of us are allowed to leave the home for exercise in a public outdoor place with one other person who's not a member of your household or your support bubble. So that's a difference this time. We are allowed to be outside to exercise with another person. And paragraph 3 applies in determining whether a person is complying with the limits. Now, we'll come on to that in a moment. The same scheme works for being out of doors and out of your home to visit a public outdoor place. You'll see that it's exactly the same, I think, in terms of the, yes, I think it's exactly the same, in essence, as the exercise exemption. And then there are others, attending a place of worship and so on. But those are the two that I would say are likely to be particularly important for those with care and support needs. You can leave the home to take exercise or to visit an outdoor place, either alone, with your household, with a member of your support bubble, or with one other person who's not in your household or your support bubble. Skipping through those that aren't particularly related to care and support, we then have paragraph 3. This is very important and potentially controversial, I suggest. So for the purpose of determining whether a person is complying with the limits in terms of the number of people who can do these things, no account is to be taken of any person who's present as a carer for a person with a disability who needs continuous care. Now, that's obviously positive for those with care and support needs, because it means that they can add their carers to that package of people without them being taken into account. But there's this somewhat challenging, I'd suggest, phrase, continuous care. What does that mean? And why should it be that a person who perhaps doesn't need continuous care, but who may need care and support while they're out of doors, isn't able to benefit from that exception? And that may be something we need to discuss. Also, it then provides in relation to these exceptions or certain exceptions, no accounts taken of a carer or children below the age of 5. But provided that, and this is the second problem, in either case, there are no more than 2 people present in the capacity of carer. So that's the second issue, I think, with what's is obviously intended to be a benefit for disabled people, elderly people, and their carers. What about if the person needs 3 carers? Because in that context, the third of those carers does count, or 4 or 5, and that's already come up in certain of my cases, and it's an issue that we're looking to address. So you can only discount 1 or 2 carers in this regard. Now, the other exceptions then very importantly for our purposes, include work. So exception 2 is that it's reasonably necessary for P, and P in this context is the person who wants to leave the home, to leave or be outside their home for the purposes of work or to provide voluntary or charitable services, where it is not reasonably possible for P to work to or provide those services from home. So it's not a blanket exception. Sometimes I think it's been misreported as being a blanket exception that anyone can leave the home for work purposes. That's not right. It has to be reasonably necessary for you to leave the home for work, and it has to be not reasonably possible for you to work at home. Now, in the care and support context, that may well be straightforward, but it is worth bearing in mind, I suggest. It's also possible to say that you're leaving the home because it's reasonably necessary for you to do so to access education or training. And that will include provision, for example, for disabled children and young people. You can also leave the home to provide care or assistance, and that's a general exception, including, importantly, relevant personal care. So it doesn't have to be relevant personal care, but that's one specified entitlement. You can leave the home in an emergency to provide emergency assistance to any person, to fulfill a legal obligation, to access critical public services, including social services and services provided by the Department for Work and Pensions, and importantly, again, for people in need of care and support, to access services provided by voluntary or charitable services, including food banks. So if a charity is continuing to provide a service during lockdown, and it's reasonably necessary for you to do so, you can leave the home in that regard. There's then the elite athletes exception. Medical need might be relevant, of course. So if it's reasonably necessary for you to leave the home to seek medical assistance, etc., you can do so. But also, very importantly for our purposes, to visit a person receiving treatment in a hospital or staying in a hospice or care home, or to accompany them to a medical appointment. And the person leaving home is either a member of their household, a close family member, or a friend. So distant family members presumably would have to say they were friends in order to qualify here. So it's very clear that as a matter of law, we can leave the home to visit people who are in hospitals, hospices, or care homes. Whether that hospital, hospice, or care home will admit visitors is another question, and perhaps one that Sian is going to be better placed to answer looking at the guidance. There's now an exception that's specific in relation to support and respite. So it's exception 5 here. So we're allowed to leave the home to attend a meeting of a support group that's permitted to meet under Regulation 11. We'll have a look at what that means in a moment. And then for the purposes of respite care or short breaks, as they're often referred to in relation to children. So a specific exception if the person is going for a short break away from the home. Exceptions in relation to deathbed visits and funerals, marriages and civil partnerships. It's actually a very narrow exception there. Children may be relevant, of course. There's various exceptions in relation to children, the most obvious one being where the parents are separated, but there's a range of others as well, including childcare related exceptions. Animal welfare, returning home, prison visits, and other visits. So that's the full range of exceptions in Regulation 6. But what I would return to is what I said at the very beginning here, which is that these are not what lawyers would describe as exhaustive of the reasonable excuses. They are things which are included within the concept of a reasonable excuse to leave the home. But the key legal test, the acid test, if you like, is that no person may leave or be outside of the place they're living without a reasonable excuse. So the question is, do you have a reasonable excuse to be outside the home? So that's the first part of the implications of lockdown for care and support. The second then is these restrictions on gathering. And you'll see here that the regulations cover 3 different types of concern in relation to gathering: participation in indoor gatherings, participation in outdoor gatherings, and organising or facilitating what's described as a relevant gathering, which is a large gathering. So we start with some general interpretation in Regulation 7. And we're told, first of all, what a gathering is. So a gathering takes place when 2 or more persons are present together in the same place in order to do anything, essentially engage in any form of social interaction or undertake any activity. There's then a definition of what indoors means. See the smoke-free premises regulations, definitions of public outdoor places, private dwellings, and so on. So you might need to look at the interpretation regulation if it's unclear. We then have the participation in indoor gatherings provision. Now, this is probably the most relevant type of gathering for those in need of care and support, although outdoor gatherings will be highly relevant as well. And we see that the scheme here is quite different, because under Regulation 8, no person may participate in a gathering which consists of 2 or more people and takes place indoors. But that does not apply if any of the exceptions set out in Regulation 11 apply. So in relation to gatherings, the exceptions are exhaustive. You have to come within Regulation 11 if you want to gather with another person indoors. And we'll see under Regulation 9, because outdoor gatherings, the same approach applies. So right at the end here, paragraph 1 does not apply if any of the exceptions set out in Regulation 11 apply. So for any kind of gathering, there has to be an exception in Regulation 11. Before we go to Regulation 11, very important again to look in terms of outdoor gatherings at this supposed benefit, and it is going to be a benefit for many disabled people and those in need of care and support. But when you're determining whether there is in fact a gathering of 2 or more people, no account is taken of any person who's present in the gathering as a carer for a disabled person who needs continuous care, providing there's no more than 2 people present in that capacity, or a child below the age of 5. So again, carers are permitted to attend to support a disabled person, for example, to meet up with a friend, as long as that person needs continuous care and there's no more than 2 of them, both of which may cause an issue in particular cases, unfortunately. Regulation 10 is then this concept of relevant gatherings, large gatherings of more than 30 people. We won't dwell on that. And now let's look at the exceptions. So of course here, this is really important because we have to have an exception to gather otherwise than in relation to outdoor gatherings where carers are involved. So again, the first exception is that you're part of the same household or you're in a linked household, straightforward. Second is, again, the gathering is reasonably necessary for certain purposes, which are familiar from Regulation 6, work, educational training, emergency assistance, avoiding injury or illness or escaping a risk of harm. Providing care or assistance to a vulnerable person is always then, as long as it's reasonably necessary, a reason to gather, including, brackets, but not limited to relevant personal care or a house move. Legal obligations, criminal justice, support groups. So this is important. So a gathering of a support group consisting of no more than 15 people and taking place at premises that aren't a private dwelling are allowed as long as it's reasonably necessary for members of the group to be physically present at the gathering. And again, no account taken of a child who's below the age of 5. And the definition of support group is a group or one-to-one support which is organised by a business, charity or public body to provide mutual aid, therapy or any other form of support to its members. So it's quite a generous definition. And again, for example, in relation to the issues that follow below, but those are not exhaustive. So that's important. Also important, again, is respite care. So the gathering is permitted if it's reasonably necessary for the purpose of respite care or short breaks. Exception 7 is going to be relevant, births and visiting persons receiving treatment, etc. So attending a birth or, for our purposes, again, similar scheme here, visiting a person receiving treatment in hospital, hospice or care home, if you're a member of the household, a close family member or a friend. That's permitted by way of a gathering. The marriage exception, very limited one, as I've said, visiting a dying person, funerals and related events, elite sports, again, a similar set of exceptions in relation to children, and then some other specific exceptions, Remembrance Sunday and Armistice Day. But of course here, we don't just say, or anything else. Here, you have to come within one of these specific exceptions. And so just recapping, most of the time, it will be either because you're in the same or a linked household, or because you're working or accessing education or training, or providing care and assistance to a vulnerable person, or because you're attending a support group, or because you're accessing respite care, or because you're visiting a person receiving treatment in a hospital or staying in a hospice or care home. And note here, of course, there's no limit on the number of visitors, on who can be a visitor, as long as you're a close family member or a friend. So the guidance, as Chum may show you, goes beyond that, but the law is very clear that anyone who is visiting a person in those settings is allowed to do so, in the sense of being allowed to gather. So that's regulation 11, the exceptions on gathering. Just before I hand over to Sian, before I take some questions, I also need to give the definitions of linked household and linked childcare household. And those are in regulations 12 and 13. The regulation 12 is the definition of a linked household. So it's a household that's linked with another in accordance with this regulation. And essentially, as people will probably be aware, this is for single adult households. So where a household comprises one adult, or one adult and one or more children, the adult may choose to be linked with one other household, the second household, but only if all adult members of the second household agree, neither household's linked with anybody else, nor were they in the previous lockdown. And importantly, there's then no limit on the number of adults or children who may be in the second household, and then they become linked households. They cease to be linked households if anything goes wrong in relation to the condition in paragraph 2. And if they do cease to be linked households, you can't link with anyone else, which is a question I've been asked previously. So it's a one-shot deal, I'm afraid, linking your household with another. So very often it will be, for example, a single parent with their children linking with a set of the grandparents. That would be a very obvious linked household arrangement, but it could be anything. Any single adult household has the right under the lockdown regs to link with another household of any composition. Once you've done that, that's it. You can't do it again. Linked childcare households are then essentially a species of linked household. So it's a household that's linked with another for the purposes of informal childcare. So where the household includes at least one child aged 13 or under, the first household, that household may link with another household for the purpose of the second household providing informal childcare for the child. If neither household is linked with any other household in accordance with this regulation, and all the adult members of both households agree. And so the first and second households become linked childcare households in relation to each other. So you can provide childcare across the two households. They cease to be linked childcare households when there isn't a child aged 13 or under in them. And if you do cease to be linked, again, you can't relink with anybody else. So it's a very narrow, again, exception. Those two key definitions are familiar, I think, now to many people, but perhaps you won't have seen the technicalities before or where to find them. So before I look at the questions, I think Sian's going to helpfully go through some of them that have been coming in and perhaps some that have come in advance and put me on the spot with them. Just a reminder of the structure of the regulations and where to find the things you'll need. So when you're looking to understand whether you're allowed to leave the home, the exceptions are in regulation 6, but bear in mind that these are not exhaustive. You could have another reasonable excuse. When you're looking to whether you can gather indoors or outdoors, the exceptions are in regulation 11, and these are exhaustive. You have to be within one of these and be confident that you're within one of these, otherwise you're potentially committing an offence. And if you need to know about linked households or linked childcare households, they're in regulations 12 and 13, as I've just shown you. So I hope that was a helpful whistle-stop tour through the new lockdown regulation scheme. Of course, at present, these only remain in force, I think, until the 4th of December. But there is, of course, the potential for this to be extended. So it may be of relevance beyond that, but it's certainly of relevance for roughly the next month in terms of what people in England can and cannot do by way of leaving their home and gathering. Sian, I think I hand over to you now to for some questions.
Yes, as you'd expect, we've got a lot of questions, and I'm going to apologise to those whose questions we don't get to, but I've picked out some of the ones that I think are the toughest ones for you, Steve.
Oh, thanks, great.
So the first one, which I thought was a good question, is about the meaning of continuous care.
Yes.
And I suspect this is one that may be the subject of some judicial consideration in due course. But do you have any views on that?
Well, I think it's a really problematic phrase, frankly. I haven't had a chance yet to plough through all the different welfare benefits regulations to see if it's a phrase that's used in any of the benefits. But if it doesn't, even if it is, it doesn't automatically take its meaning from a different statutory context anyway. So it's care which is continuous, isn't it? That's all we know. Does that mean continuous throughout the outing? Does that mean that their person literally needs to be cared for every single second of the day? Does it mean that, broadly speaking, they have an ongoing need for care? I think you're absolutely right, Sian. Until a judge considers it, we simply won't know the answer to that. I'm afraid, if I had to guess, and I probably do, so I'm answering the question, I think it means someone who has a very high level of care needs all the time, that continually needs care. I don't think it's restricted just to the period of the outing. And I think that on its natural reading, it does mean an ongoing need for care. So care needs all the time, not literally every second of the day, but continuously.
But care can also include supervision, can't it?
So
there might be some scope there.
I think that's right. But of course, the difficulty with all this is that you're dealing with a situation where if you get it wrong, there's criminal sanctions. Now, we know that in reality, I saw the coverage today saying the police have been told not to take a punitive approach, but you can never be sure that yours won't be the exceptional case where someone does. And I think people are entitled to have a good degree of clarity about what they are and are not allowed to do and whether they're going to break the law. I mean, I think there's also, having said all that, it's also important to take a purposive approach to this. And clearly the purpose is to benefit disabled people. This has been put in as an attempt to make it more possible for people with significant levels of need to access the community during lockdown. So on a purposive approach, I hope a generous interpretation will be taken, but I don't think we can give any guarantees, can we? And one of the features of lockdown has, of course, been a great deal of confusion about the nature of the offences, the nature of the restrictions. I think one analysis, all of the lockdown offences were unlawful, weren't they? Because they'd all been charged under the wrong regulations. The Welsh ones have been charged in England and against the English regs and vice versa. So it's difficult for lawyers sitting in our rooms to say, oh, it definitely means this, until a judge tells us that, I would say. So I'm sorry, that's not a very helpful answer. Clearly, the more significant the needs of the person are, then the more likely they are to be treated as continuous. And I do think it's right, as Sian says, that care includes supervision. So it doesn't mean that someone literally needs personal care 24/7. That would be absurd, wouldn't it?
So just another perhaps related question. If somebody is actually receiving 24/7 care or is in a placement providing such care, is it essential for somebody else to leave their home to go and provide care to that person? Does that fall within the definition of essential care?
Well, that's a really good question. I don't think it does, no. But bear in mind, so if we think about in the context of the leaving home exceptions in Regulation 6, first of all, you've got a number. You could, for example, be buying goods or obtaining services for that person. That could be a reason to go and see them. You could be visiting them, as we've said, with the specific visiting exception, to visit a person receiving treatment in a hospital care home. And you'd imagine most people who are getting 24/7 care would be in one of those registered settings as opposed to in their own home in a supported living arrangement, because that clearly doesn't fall within this exception. You could be taking them to a support group or respite care. But again, I would stress that you don't need to prove one of these exceptions in order to justify why you're not at home. So it's not quite as critical here as it is when we get to Regulation 11. And just on the narrow point about the specific test here, the question is it reasonably necessary for you to go there to provide care or assistance? That doesn't mean that you'd have to say, well, without me, they wouldn't get any care or assistance at all. It's just got to be more than desirable. And there's been some case law, hasn't there, that necessity is a spectrum that goes somewhere between desirable and absolutely essential, in essence. And so you just have to be able to come within that. And I think the use of reasonably there does give a significant degree of wriggle room.
And then another interesting question about under what provision would the person who is visiting someone in a care home in the role of attorney or deputy or legal representative fall? I think legal representative is quite easy because
Yes.
obviously the business of justice continues.
Yes.
But perhaps those who are attorneys or deputies might not quite fall within that. What do you think?
No, I think that's right. So they probably, I think most of the time we're looking at exception 2, by the way. This is the sort of broad set of exceptions. And it would probably be here voluntary services, or if they're an unpaid representative, or assistance, I would suggest. They'd be providing assistance, wouldn't they, in terms of, for example, helping them to manage their managing their finances for them in the context of a finance attorney. So I put it this way, I'd be extremely confident that someone who's doing what Sian's just described will have an exception to fall within. And you might well come within a number of them, and there's no difficulty with that at all.
And then another interesting question about support groups. If the support group is limited to 15 people, in your view, does the 15 people include those who are facilitating or organising the group?
Excellent question. So let's look again at the definition. So Regulation 6 cross-refers to Regulation 11 here, which obviously is the hard-edged exception. So there's no surprise in that. So if we look at how a support group was defined, gathering is of a support group consists of no more than 15 persons. So my take is that that does include facilitators. So that's all the people who are in the premises are must not be more than 15. And that's reinforced, I think, by the fact that there's the specific exclusion for young children. So if there were going to be other specific exclusions, like for organisers, you'd expect them to be set out. So my take is that it's at least likely that the 15 is a cap for participants and organisers.
The 15 is also the cap number that was used for weddings, wasn't it?
That's
right. And that was a total number rather than excluding the celebrant. So that might give a clue as to...
I think so. I think, again, when you've got hard edge limits, no more than 15, what you'd normally expect to see is any carve-outs from that being expressed, wouldn't you? And so like the under 5s carve-out. So in the absence of any carve-out for organisers, I'm strongly of the view, actually, that the 15 would cover anyone who's organising or facilitating.
And then one last question before we let you have a break. Can a carer plus one person who is needing care meet one other person outside? So that would give you a total group of 3. What's your view on that?
Yes, they can, can't they? And that we get from paragraph 3 here. So, well, as long as the person with a disability needs continuous care, let's assume for that purpose, for present purposes, that we're confident that they do, then yes, they can, because the carer in that scenario is discounted. No account is taken of them. And so the disabled person with their invisible carer alongside them goes to meet a friend for outdoor exercise or to enjoy an outdoor public place in the same way as others are allowed to do. So yes, I think the short answer to that question is yes, so long as the disabled person needs continuous care. Sorry, I was looking for the exercise and public outdoor place exemptions, and of course they're here in exception 1. So they are then in that context coming here within, for example, C3 in a public outdoor place with one other person who's not a member of their household. And we see, don't we, that that's... Here we go. So paragraph 2C3, no account is taken of the carer, and the carer is as defined above. So sorry, a slightly long way of saying yes.
So the key point there seems to be that the cared for person has a need for continuous care, which takes us back to the first question about what is the meaning of continuous care.
What does that mean? I mean, I think that's really unfortunate. I applaud the fact that on this occasion, the government has clearly thought about the needs of disabled people and their carers to some extent, you know, and has put in a significant exception for them. But I'm not convinced that the drafting is helpful here. in terms of that phrase, continuous care, which as far as I can see isn't defined anywhere, and is clearly, I think, at least open to a significant degree of interpretation.
What's quite interesting, I think, is that that phrase is ultimately going to have to be interpreted by the criminal courts.
Yes, most likely, unless someone judicially reviews the regulations. Because you're right, Sian, unless there's a head-on challenge to the regs, then it will be in the context of enforcement, wouldn't it?
Steve, there are lots and lots of questions. It's just
Yes.
gone up to 76 questions. But I think rather than you having to sort of sit there for the next 3 hours answering them,
Sure.
Shall we move on to the guidance and
do.
Come back to some more of these questions later on?
Great, and I'll also have a look and see if there's any that I can answer in writing while you're talking as well, Sian. So we'll see how we get on, and then I'll put some to you at the end of your talk. So I will now stop sharing my screen so that you can share yours.
Thank you.
There you go.
Hopefully everyone can now see the slideshow.
We can, thank you, Sian.
Great, okay. Right, so what I'm going to do is talk a bit about the flurry of guidance that's come out, and really try to sort of emphasise some of the key differences between what I'm going to call lockdown 1 and lockdown 2, in terms of the approach that's taken in the guidance. Steve's already talked about the difference in the regulations and the fact that some of the lessons from lockdown 1, and in particular some of the areas in which the regulations were challenged, and some areas which were found to be difficult or impossible to enforce have shaped the direction of travel in terms of the lockdown 2 regulations. And what I'm going to do is look a bit at some of the guidance that's come out and try and sort of pick out the differences. So I'm going to start with what's known as the winter guidance. This predated lockdown 2. It's dated the 18th of September 2020. But it is guidance that was produced at a time when there was the tiered system in place, and of course what that meant for those areas in tiers 2 and 3 certainly was a significant level of restriction, albeit not quite the same as the regulations that we've just been looking at. Quick plug for a note prepared by the team at 39 Essex, which is linked to in the slides. Essentially, what the winter guidance did was to describe as the priorities for social care. Firstly, ensuring that everyone who needs care or support can get the support they need throughout the autumn and winter period. Secondly, protecting those in need of care and support from infection. And thirdly, and really this is the key point that I want to emphasise, making sure that people who need care and support remain connected to essential services and to their loved ones whilst protecting individuals from infections. And in my view, that sort of summarises perhaps one of the lessons that has been learned from lockdown 1, which is this issue of the balance that's needed. Yes, people do need to be protected from infection, and those who work in a sector where there is a level of risk need to be protected. But I think what has been seen is the impact on those who need care and support from not having those connections to essential services, or who are put off from accessing services because of a perceived lack of service or risk of infection, and also the impact of not having the connection maintained to loved ones. So to summarise the lessons learnt from lockdown 1, what I see them as is firstly that safety from infection versus mental health and well-being is a very finely balanced equation, and I don't think that was at all a feature of the consideration in lockdown 1. Remote visits by family, by professionals work for some people, but by no means all. And thirdly, that across adult and child social care, safeguarding needs are slipping through the net on account of persons not being visible to services. In the area of children, that was particularly apparent when schools were closed, and that might be something that informed the decision to keep schools open so far as possible during lockdown too. Adult social care is much more difficult to maintain that level of visibility, and so it's services like visits from social workers, day centres, etc., that keep the vulnerable visible to statutory support services. So we have guidance from the Department of Health and Social Care. This was updated on the 15th of November, and this particularly relates to visiting arrangements in care homes during the period of the national restrictions. This applies for the duration of the national restrictions, so until the 2nd of December. It is non-statutory guidance, but nonetheless of considerable value. What the DHSC guidance says is that the placements facilities have to have visiting policies which are risk assessed. So the assessment, the risk assessment, should consider relevant factors, including balancing the benefits to residents against the risk of introducing infection, the ability of a particular setting to put in place practical measures in order to mitigate risk, the health and well-being risks arising from the needs of the cohort of residents. So, for example, if there is a particularly clinically vulnerable group within the care home or placement, that would be a factor in favour of a greater level of restriction than a more generally healthy cohort. And whether residents' needs make visits particularly important. And that's the flip side of the vulnerability of the group. So is this, for example, a placement predominantly occupied by individuals who would derive particular benefit or need or well-being from being able to receive visits? So it's looking not just at the individual and the placement, but also the cohort. Precautions that will be taken to prevent infection during visits, PPE, cleaning, etc. The practical effectiveness of social distancing measures between the visitor and residents where the healthcare needs of the individual cannot be met by socially distant visits. In other words, how much can be achieved by use of PPE and distancing? How effective is that going to be? And whether there are sufficient infection control measures in place to protect residents, staff and visitors. So in other words, looking more widely beyond the cohort of service users to those who are caring for them. In addition to the Department of Health and Social Care guidance, we have also had some guidance provided by ADASS, the Association of Directors of Adult Social Services, and they produced an advice note which was somewhat unfortunately timed for them because it came out on the 2nd of November, and of course that very shortly predated the announcement of lockdown 2. So in fact the ADASS guidance appears to have been written with a view to the tiered restriction structure, but nonetheless it has relevance to the current situation. And what ADASS say in that note is that their view is that blanket restrictions, i.e. rules or policies that simply say no visitors in care homes or other placements, leave providers and local authorities open to legal challenge. And even in situations where the local COVID restrictions are at the highest level, so that would have been the tier 3 situation, there must always be consideration for personal and exceptional circumstances so as to comply with public sector equality duty and human rights requirements. So in other words, what ADASS are saying is largely in line with the theme that I've been discussing, which is that just having a blanket restriction is probably the safest step that one can take in terms of preventing infection, but it's also the most detrimental step that could be taken in terms of mental well-being and the protection of people's Article 8 rights to family and private life. And so the ADASS guidance is saying that a balance has to be struck. It goes on to say that local authorities and providers must consider balancing the risk of harm and distress to residents and their families through not having visits with the risk of harm and to residents, visitors and staff through infection. Goes on to say that local authority directors should, as far as possible, work to support care providers to ensure they are not applying blanket bans on visiting. So that's a programme of dialogue, education and cooperation between local authorities and the care providers. Support care providers to develop proportionate guidance that balances risks of infection with rights to private and family life. Again, that's a role for the local authority rather than just the responsibility for this resting solely with the providers. Be conscious of the unintended consequences that can arise as a result of restrictions being applied. For example, families making decisions to take a loved one home at the end of life, likely to result in a higher demand for community-based support. I would add to that, because I've had experience recently of cases where that almost exactly that scenario has played out and has resulted in court of protection proceedings. That actually it's not just an unintended consequence being a higher demand for community-based support, but a further unintended consequence is the likelihood of court of protection proceedings, and also potentially distress and harm, both physical and mental, to the person who is being removed from a care home on that basis if they lack capacity. Support providers to ensure that visiting policies use a dynamic risk assessment process which takes into account people's personal circumstances, as well as the vulnerability of residents and the home's actual environment. That, I think, echoes the DHSC guidance, or rather the DHSC guidance echoes this, because this guidance came before, that it's a combination of who is there and what are their vulnerabilities, what are the benefits to the cohort of having a visiting policy, and also how does the environment lend itself to visiting, and how can it be adapted if it doesn't lend itself. I'm aware of placements offering a particular room which is booked in time slots for families to visit, and which is obviously cleaned in between visits. Other placements that I'm aware of have created visiting areas outdoors, so that while they're covered to protect from the elements, that there's a degree of ventilation to improve the COVID safety, again bookable by family members. There's actually a lot of good work going on in terms of trying to find solutions that balance all of these factors. But for those that are applying the blanket policies, ADASS are very clear that that's not appropriate. And then finally, local authorities should support providers to develop visiting policies that ensure people, both residents and families, have full information about the risks and benefits of visiting versus not being visited, and seek explicit consent to any restrictions. So an informed basis for making decisions about visiting. And then we also have, to add to that flurry of guidance, a letter from the Vice President of the Court of Protection, dated the 6th of November 2020, so last Friday, noting that the DHSC, Department of Health and Social Care guidance, does permit visits to those in care homes. And then stating it is recognised that receiving visitors is an important part of care home life, and that maintaining some opportunities for visiting to take place is critical for supporting the health and well-being of residents and their relationships with friends and family. That's the emphasis from Mr. Justice Hayden, not me, but it does link into that theme that actually the visits, the possibilities for contact beyond a screen or a device are absolutely crucial for well-being. And one of the things that has been seen through lockdown 1 is a deterioration in the mental well-being of many who have care and support needs because of a lack of maintenance of family relationships. Just a quick word on needs assessments, because this is a question that came up in lockdown 1 and no doubt will rear its head again in lockdown 2, in particular about how needs assessments are to be conducted, whether they can be remote or whether they should be in person, and how to make that decision. Helpfully, the care and support statutory guidance, which was obviously not formulated with the pandemic in mind, does address this issue to an extent. What it says is that the type of assessment depends on all the facts, including the level of risk. 10.31 of the statutory guidance says there may be instances where remote involvement is just as effective, such as over the telephone, through video conferencing or other means. And then in the part of the statutory guidance that talks about reviews of care and support plans, at chapter 13.15, it says that local authorities should have regard to ensuring the planned review is proportionate to the circumstances, the value of the personal budget, and any risks identified. In a similar way to care and support or support planning, there should be a range of review options available, which may include self-review, peer-led review, reviews conducted remotely, or face-to-face reviews with a social worker. So the statutory guidance is clearly envisaging there being a decision made in every situation where a needs assessment or a review is required as to the most efficacious and proportionate way of conducting that review, taking account of all the circumstances. And clearly the circumstances now include the circumstances created by the pandemic. So the statutory guidance permits both face-to-face and remote assessment. And in my view, there shouldn't be, again, echoing what was said earlier about visiting, there shouldn't be any blanket policies about this. There shouldn't be any blanket rules that all assessments must be conducted remotely, or indeed any requirement that all assessments should be in person. It involves a risk assessment and circumstances in making that decision as to how someone's needs are to be assessed or reviewed. So really, just to draw some general themes, my view is that the approach to lockdown 2 from DHSC, from ADASS, and in that guidance note from the Vice President of the Court of Protection are all much more nuanced than the slightly bulldozerish approach that was taken in lockdown 1, which was to take the word lockdown literally in some cases. The emphasis is no longer on the preservation of health, risk from infection at all costs, but there's a recognition that there's a balance to be struck between health and well-being, including the individual, the cohort with whom they reside, and the physical nature of the premises. And there are some interesting questions about how this could be enforced, because one of the possible mechanisms is that local authorities might expect arrangements for visiting to be the subject of conditions that they impose on standard authorisations granted under the DOLS provisions of the Mental Capacity Act in relation to those lacking capacity. That's in addition to what the DHSC say in their guidance about the need for local authorities to work with providers. I'm sorry, it wasn't the DHSC, it was ADASS, to work with providers in developing individualised risk assessments, which take account of cohort, premises, etc. So there's some interesting issues ahead in terms of how this more nuanced approach is to be enforced. thank you all very much.
Excellent. Thanks very much, Sian, for that very, very helpful review of a range of different guidance documents. A lot of my questions are going to start with the phrase, but what about? So the first of my but what abouts for you, Sian, is supported living. And a number of people have asked, well, can we just treat supported living like care homes? And I've been battering away answering those questions in writing, but I've seen there's so many of them, I'm actually going to ask it to you if that's okay. So can we just assume that if someone's in a supported living arrangement, it's the same as care homes?
Not necessarily, I think would be my answer to that. And I think I'm going to answer it in that sort of infuriatingly lawyerly way and say it depends on all the circumstances.
Yeah.
Supported living placements, they are regulated by the CQC. They're treated in the same way as care homes for the purposes of being specified accommodation for the purposes of ordinary residence. So they do have a lot in common with care homes, but also that there are many differences. And supported living placements, for example, can include people having their own front door, their own tenancy of a self-contained flat. And I think to say that supported living placements should be treated in the same way as care homes somewhat overlooks the many different types of supported living placement and the different physical characteristics of a supported living placement, as well as perhaps the different needs or the different size of placement. So I'm afraid I'm not going to answer that. I'm just going to say, no, I don't think you can just treat them as if they were care homes. But obviously, if a supported living placement is more along the lines of a care home, such as a shared house type arrangement, rather than a group of people who have tenancies of their own flats, there might be an argument for saying, well, actually, it replicates a care home more than it replicates individual living arrangements.
And that's a much better and more nuanced answer than the one I was giving in writing, which is essentially to say, no, Sian, I agree with you, actually. But I do also think that the visiting exception for care homes is obviously intended for legal things that are legally a care home. You can't get around that.
No, absolutely. Care home does have a very clear definition within the legislative scheme for regulation. And I don't think there's an argument for saying a supported living arrangement should be treated in the same way for visiting purposes.
Exactly. But as I hope I showed people in my bit of the talk, you don't have to come within that exception. There could well be other reasonable excuses to leave the home or other specific exceptions in Regulation 11 to actually go into a supported living arrangement. And one of the ones that I've been answering a lot on the written chat was the work exception. You need to, if you're an AMP, for example, you need to go and visit someone as part of your work to assess them. That's the most obvious exception, isn't it? So
absolutely,
not too hung up on any individualized exception and its technical meaning. If you don't think you can fit within that, find another one. There probably will be another one. But
the other possibility, of course, is that those in supported living may not have continuous care provided to them by a care provider. Some of their care might be provided, for example, informally, and so if an informal visitor is providing essential care to someone in a supported living placement, then they would fall within an exception as outlined earlier anyway.
Yeah, absolutely right. So what about hospital visits, Sian? What can we tell people about hospital visits?
So the hospital visit, again, is a question of assessment by the hospital. I'm going to say the same thing, no blanket policies. It is, again, a more nuanced situation. And I think there has been a recognition that tragically, a lot of people were at end of life in hospital or very seriously ill without access to their loved ones. And I think that the detriment of that has been recognised. Every hospital is going to be different. Probably every ward of every hospital is going to be different in terms of its geography, its cohort, etc. So I think if there's one theme that I'm going to keep repeating, it's no blanket policies.
Couldn't agree more, Sian, absolutely. Interestingly, when I checked this morning, it doesn't look like the hospital visiting guidance has been updated for lockdowns.
No, it hasn't.
Still the October
I'm
version,
sure we can
isn't
expect that shortly.
Well, probably. But I mean, obviously, that's a good thing for people who want to visit loved ones in hospital, because the October visiting guidance is reasonably generous, isn't it?
Yeah.
But there is another arbitrary rule, isn't there? Oh, sorry, perhaps I'm over-egging the pudding there. Arguably arbitrary rule. Perhaps I'll ask this as a question. Do you think the fact that both the hospital guidance and I think the care home guidance says no more than 2 visitors and suggests that that's an absolute limit, do you think that's a reasonable thing for the guidance to say?
I don't think there can be any hard and fast rules here. There are going to be some hospitals and some care homes that probably have a lovely large communal area, which could easily accommodate 4 or 5 people socially distancing for a visit. There are going to be some that have had to repurpose a broom cupboard for the purposes of visiting, where perhaps having 1 visitor is the maximum that you can achieve. So I really do think it's a question of, to use a housing law term, space and arrangement in every place where these visits are happening.
Absolutely. Okay, I have to ask this question, but it's probably more of a question to me, and I'm not entirely sure of the answer yet, Sian. So I'm going to see if you know the answer while I do a very quick bit of looking up, because it's come up loads of times through the Q&A. Can someone be in a support bubble, so a linked household, and be in a childcare support bubble, i.e. a childcare linked household, i.e. 2 separate arrangements? Or do you have to choose between being in a linked household and a childcare linked household?
I think the answer to that is that you can only be in 1 bubble. But I think it is too. I'm not going to tell you which bit of the regs I get that from, because I don't know.
It would be surprising if you could be in both, wouldn't it? Because that's not how it's been suggested in any of the guidance that I've seen so far.
And just thinking about the purpose of bubbles, so bubbles were created as an exception to the no mixing between households rule.
That's right.
So just thinking about the way that you interpret exceptions, it tends to be narrowly. And so I think my view would be, just from first principles, that unless there is a specific provision which says you can be in more than 1 bubble, because the bubble is an exception to a no mixing rule, it's probably limited to 1 bubble.
Yeah. So neither regulations 12 or 13, as on my quick skim, preclude it, because they just define the 2 different types of, let's use the term everyone uses, bubble. But I have a feeling when we get into regulation 11 and we look at those exceptions there, then we may find that there's a...
If I stop sharing, you can share.
Thanks, Sian. This is obviously hugely important. I totally agree that we need clarity about this. And I'm afraid I'm just still, having done 3 minutes of research, not clear, I'm afraid. Because if we look at regulation 11, the first exception, I hope I'm sharing now, is that everyone's a member of the same household or a member of 2 households in relation, linked in relation to each other. See regulation 12, you get a definition there. Seeing if that's where the exception is for. And so there's the exception for childcare linked households, which is a different exception, exception 13. So it doesn't seem at the moment like you're expressly forbidden from being in a linked household and a childcare linked household. Although I agree, Sian, that you'd expect you would be, based on the purpose of all of this and what's been said publicly. So perhaps what I can do is ask you another question, Sian, and keep digging around and see if I can find anything else of any use on this. It may just be one of those things that, unfortunately, at the moment,
an interesting question.
We can't really answer, and it's not surprising, perhaps, to be fair to the drafters. These regulations are incredibly detailed. They're incredibly ornate, almost. They've learned a lot, as Sian was saying, from lockdown 1, haven't they? But it may be that some of it still isn't quite nailed on, because they're having to do it at an incredibly short notice. I mean, what we were told, weren't we, was that they decided to go into lockdown, I think, on the Friday night, and the regs came out on the Tuesday. So that's an incredibly swift bit of drafting by those responsible for it.
From a slightly geeky point of view, I'd be quite interested to see what further nuances would emerge if there were a lockdown 3. But on a personal level, I really hope we don't get that.
So we're not. Certainly someone on the Q&A thinks that they're separate, so thank you for that contribution. I won't say the name for GDPR purposes, but thank you for that contribution. Now, another interesting definitions question. We've seen various exceptions for children and children under 5 or children under 13. As far as we can see, I think this is right. Unlike in other statutory schemes, there's no benefit for disabled children up to 18, for example. So we know, for example, under the Childcare Act, there are specific obligations that go higher in terms of age range for disabled children. I don't think there's anything here on that, Sian, is there? No,
there isn't. And that does seem to be an omission, because you've got provisions, as you say, relating to children under 5 who are disregarded for certain purposes. You've got the childcare provisions relating to children under 13. But nothing that addresses the situation of a child between 13 and 18 who may well require care, notwithstanding the fact that they're over 13. And that seems to be potentially something that conflicts with the Equalities Act.
It does, doesn't it? That may well be another one that is the subject of some judicial consideration at some point. Might have an answer on the previous question. Let me share this and see what you think, Sian. So we're looking at this question about, can you be in a linked household and a linked childcare household? Can you have a support bubble and a childcare support bubble? Now, the definition of being a linked household in Regulation 12 applies only if these things in paragraph 3 are met. So first of all, that all adult members of the second household agree. But then look, neither the first household nor the second household are linked with any other household for the purposes of these regulations. And that would, I suggest, mean all of the regulations, wouldn't it? Not just Regulation 12. So that does seem, I think, tell me if you think I'm right, Sian. This is really.
I agree with you.
Legal research on the hoof, isn't it? But
yes, but I think that must be right. And looking at the way it's drafted, that those conditions all have to be met.
Yeah.
So it is a provision that says that the household doesn't have any link with any other for the purposes of these regs or any other regs made under the 84 Act. So it's fairly wide encompassing in terms of the linked household.
Yeah.
So yes, I think that may be the answer.
I think it is. And also, of course, even if you link with someone else in the previous lockdown between the 4th of September and 5th of November. So that's not the lockdown period, that's the preceding tiers period, isn't it? You're out as well. So I'm afraid that this is probably a really good point to mention the thing I should have said in the introduction, which is that neither Sian nor I are giving any legal advice this afternoon, as it is now. We're obviously exploring the legal implications of all of this, and hopefully the way that people are finding helpful. But you'll understand that some of these points are emerging, and in any event, we can't give advice in webinars. Really probably should have said that at the beginning, but there you go. So I think
we're exploring it in real time because this stuff is so new.
Exactly, literally live and as we speak. Anyway, I'm sorry, I essentially jumped back in there to take a question that was really more aimed at my side of the talk. So interestingly, Sian, perhaps this is something you might want to have a think about. The suggestion is that the guidance says that if you're eligible, you can form a childcare bubble and a support bubble with different households. So we might need to see if the guidance is clear about that, and it might be that that's an issue where the guidance and the regulations appear to be inconsistent. Then
that's interesting. If that is the case, then I think my view is that the likely position is that it's the regs that are to be followed rather than the guidance, because the guidance is just guidance and it's not even statutory guidance. So I think if you want any clarity on this, then it's likely to be the position in the regs that will prevail.
Well, it has to be, doesn't it? Yeah, if the regs are clear. So let's see. Let me ask a slightly different point, Sian. It's kind of a practical point for you, if I may. People put in the point that in reality, lots of care homes aren't actually allowing visits at the moment. And a specific kind of sub point to that, which is insurers are creating a barrier, it's suggested, in terms of people adopting more flexible approaches. What can we do about that, would you say?
Yeah, there are a number of questions that have been sort of bubbling, I think, since lockdown one on this. One of the sort of possible mechanisms is where P lacks capacity, a Dole's condition. Obviously, that doesn't address the insurance issue, which is a matter that the care home would have to resolve. But the other, and it's a fairly drastic solution, but it has come up in a number of court of protection cases that I've been dealing with recently, is to really question whether it's in P's best interest to be in that care home in circumstances where the care home is operating a very restrictive regime around visiting, possibly a regime which isn't in accordance with the guidance, and that's having a detrimental effect on P's well-being. At the beginning of lockdown one, when we all thought this was going to be for a few weeks, I think the general view about lacking access to those in care homes was that it was just something that everyone had to put up with because it was for a short period, with the hope that the virus would be controlled quite quickly. Obviously, we're now many months down the line, and there's some empirical evidence out there about the detrimental impact on well-being for those who haven't had access to family and friends. And we are starting to see that the guidance that I talked about, taking that more nuanced, balanced approach. And I think care and support needs assessments and care reviews have to factor that in. If P is in a care home which is refusing to allow visits or being very restrictive about visits, such that it's impacting on the well-being of a person, then that may not be the placement that is meeting their needs. A person's needs include, as we know, managing and maintaining family relationships. Some people can't do that by video, or it's not enough to do it by video. And if that need isn't being met, then the placement may not be meeting their needs, and therefore may not be a lawful discharge of statutory body's duties under either the Care Act or the National Health Service Act.
That's really, really interesting analysis, Sian, and I agree with it entirely. The other thing we have to say at this point, and it's quite surprising we've got this far without either of us saying it, is human rights, of course. The human rights implications of these restrictions are hugely significant. And it's worth bearing in mind that under Section 73 of the Care Act, registered care providers who are providing local authority funded care are expressly public authorities for the purposes of the Human Rights Act, and so can be challenged for measures that might be, for example, a disproportionate interference with the person's right to respect for their family life or their private life that includes their relationship with other important people. And my view is that given that, other care providers, at least of publicly funded care, will be as well. So the possibility of human rights challenges to disproportionate measures, Sian said, blanket policies being the most obvious, but not just, just because something isn't a blanket policy doesn't automatically make it proportionate. So there's that set of considerations that need to be borne in mind as well.
The other thing I would say is, of course, moving somebody from a care home potentially breaches Article 8 in that the care home is their home. It may be somewhere where they have private life relationships with other residents. So moving someone isn't always a complete or easy answer. But there may be a need to look at whether there is, in Mental Capacity Act terms, a less restrictive option, somewhere that they could move to that has a less restrictive regime, or a means of making the current placement less restrictive. And hopefully, in terms of the insurance issue, now that the regulations and the guidance take this more balanced approach, that might impact the approach that insurers are taking when care homes are looking at their risk assessments.
Yeah, I agree. I mean, the care home visiting guidance is nuanced to the point, arguably, of being unhelpful, I'd suggest, in that it really does just leave it up to local areas, doesn't it? And there's certainly no comfort in that guidance for blanket policies, blanket restrictions at all. But at the same time, it says, really over to you, local directors of public health and local providers. So there will need to be individualised challenges if particular homes or particular areas are adopting arguably disproportionate policies and have to be challenged on a case-by-case basis.
Yes.
Can I just come back to this thorny point though, Sian? Sorry to interrupt, about the linked households, because I've got it up on the screen. We might be wondering why I've highlighted paragraph A. This really is rock and roll lawyering, because not only are we trying to work it out on the hoof, but I'm also getting WhatsApp messages, thank you for that, and comments on the chat as well, the Q&A, pointing out that actually the restriction we were looking at before doesn't apply to Regulation 13. So linked childcare households are carved out as being a separate group, and linked households are allowed to link even if they are in a linked childcare household arrangement. So it looks like the guidance is right, in fact, and you can be in both a linked household and a different linked childcare household. That seems to be the latest state of play, Sian. Do you agree? And
so how does that, if that's the position, how does that impact on any linking arrangements that someone had in a previous iteration of the lockdown?
Yeah, that's a tricky one, isn't it? Because the references in paragraph 3 to neither household being linked with any other household don't include being linked with another household only for the purpose of informal childcare in accordance with Regulation 13, or any other regulations, which I think must include any other previous regulations. So I think if you were in a linked childcare household at any point, you can still, but only that, you can be in a linked household as well now. But if you've ever been in a linked household, bizarrely, one might say, you can't be in a different linked household now. So
your linked childcare household is fixed, but
yes,
you can then link with another household.
Exactly. At any point, it seems, a person can have one linked household and one linked childcare household, but no more than one of either of them. Do you think we're there?
I think that must be right. Looking at it, yes. I'm not going to sign off an advice to that effect.
Neither am I. But that seems. Thank you for the what's the word I'm looking for? Collaborative legal advice, crowdsourced legal advice.
Absolutely.
We're trying to, Sian and I are in the process of, but have not actually worked out.
It's a new form of entertainment.
Well, exactly. Yes, that's where we are. That's where we're up to in lockdown too. Sian, can I ask you another what about question? Unless there was anything else you wanted to say about care homes, because I interrupted you. What about people who have PAs, personal assistants? Do you think there's anything specific about that kind of arrangement that people need to take?
Well, the only thing to emphasise, and I think it was something that actually hasn't changed from the previous lockdown, but was misunderstood at the time. Nobody is precluded from going to work if they can't work at home. So the first question is, can I do my work at home? And if the answer to that is no, then there's nothing that prevents anyone from going to work. And I know that certainly in my experience, there were cases of PAs, for example, saying, oh, no, I can't come to work. They absolutely can. But of course, there is a duty as an employer of a PA to risk assess and to risk manage as much as possible, and to try and provide what's called a COVID secure environment as much as possible. But there isn't any restriction on a PA carrying out their role.
I think that has to be right, doesn't it? And other than that, it's everything else is the same. All other things are equal. So the PA clearly can use the work exceptions. The cared for person will need their own exceptions to be able to, for example, leave their home, or indeed also to gather, won't they? So that there's a slight concern I have here about, it's quite straightforward actually for the professionals. They're just working and it's reasonably necessary. But then the person who's receiving the service also has to have an exception in order to not be breaking the law in terms of gatherings, don't they? So that will come back, I presume, to the care and support exception often, won't it?
Yes. And also, just as a reminder, there is that provision which allows more than two people to be in a gathering if one of them is providing care to one of the others who are present. So that would allow for the situation where the PA, for example, accompanies the cared for person to a park to take exercise together with one other person.
Yeah, absolutely. Sian, a couple of follow-ups to points you've made already, if I can. Were you suggesting that supervisory bodies could put a condition that the managing authority have to allow a family member to visit?
In theory, they can, yes. Yes.
Yes, I think that's right.
I mean, I haven't actually seen it done yet, but it seems to me that if it's in P's best interests and it's not happening, then I wouldn't say that the first port of call should be a condition, but if negotiation and dialogue don't work, then potentially that could be imposed as a condition. It carries some risks, because the placement might say, well, we're not able to do that, for example, because our insurance doesn't cover it, and therefore give notice on the placement. So I'm not suggesting it's an easy answer.
No, at which point you could potentially judicially review the placement, couldn't you, if they're a public authority under the Care Act? So round and round it goes. I mean, this isn't supposed to just be about making work for lawyers, but it could unfortunately involve quite a lot of work for lawyers, couldn't it? Because there's a number of different points of challenge on there in a case
but
like that.
If the placement has not risk assessed, or has one of these blanket policies, then I would say that a Dole's condition is a theoretically available mechanism by which local authorities can try to nudge providers to do what they're supposed to do under this guidance, which is to risk assess and have an individualised plan.
Absolutely.
Obviously, the local authority should also be doing what the DHSC and ADASS say they should do, which is to work collaboratively with the providers, so that the providers are supported in assessing their own situation.
Absolutely. So how about this one then? So a whole county seems to have a blanket ban on visiting. And when questioned, they say they're adhering to Public Health England guidance. And therefore, the point's made by the questioner that actually moving to an alternative care home isn't really going to work, because they're all going to be operating the same policy. What would we do in that situation?
Well, if it is a county-wide policy that visits are not permitted to those in care homes, then I would say that there is a question about whether that's lawful.
I agree. And the challenge then would probably be to the county, to the local authority, wouldn't it? And judicial. The
care homes
standard
would presumably be carrying out the county policy, and will not have done their own risk assessments, etc. So I would say that it has all the hallmarks of being the sort of blanket policy that can't possibly be compliant with human rights obligations, Equality Act obligations, or indeed Care and Support Act obligations.
Or really just straightforward common law, either. It's just not rational, is it? Agreed. So in that, the short answer to that might be get legal advice, I'm afraid. Is there any specific guidance on residents in care homes accessing the communities? So we know there's visiting guidance. What about the other way around, people who live in care homes and want to go out?
Not that I've seen. No, is the short answer to that.
Is the reason for that just because it's obvious that they can? I mean, unless there's a legal impediment for people doing so.
Well, those in care homes are subject to the same restrictions as the rest of us. They can go out for essential purposes. Just because someone's in a care home doesn't mean that they're not able to go out for all the purposes that we're all allowed to go out for according to the regulations.
Absolutely. And that was one of our advanced questions, wasn't it? Was the suggestion that a care home had somehow banned its residents from leaving the home. And you're thinking, well, on what legal basis do they think they're doing that? I mean, that's often when I'm asked questions like that, my immediate reaction is I can't understand why they think they can do that. It's not so much a question of why they can't do it, but how do they think they're able to stop people from leaving? Certainly those who have capacity.
Certainly if someone's got capacity, it would. I can't see any basis on which they could be stopped. If a person lacks capacity, then it's a best interest decision. And I know in lockdown 1 that there were some interesting questions around those lacking capacity wanting to leave placements, but not having the capacity to understand or to make decisions relating to social distancing. And so that might be a sort of an aspect that feeds into a best interest decision around someone leaving the care home, although the obvious thing that springs to mind is that it could be addressed by support and supervision rather than by preventing them from leaving. And under the Mental Capacity Act, obviously, we're always looking for the least restrictive option. So I can't see any basis for any, again, blanket rule that says those in care homes can't leave. There needs to be consideration on a best interest basis of the community access of anyone who doesn't have capacity to make that decision for themselves.
I mean, that has to be right, doesn't it? And also, I think to emphasise it, in lockdown 2, the regulations specifically have an unlimited entitlement to leave the home when reasonably necessary for outdoor exercise, and to visit outdoor public places. So quite rightly, the government has recognised, one assumes that some people can't exercise in the traditional, way of jogging around the park. You're allowed to just go outside and be in a park or a public garden, because that itself has health benefits, and you're allowed to do that whenever is reasonably necessary. So the best interest analysis this time round has to take into account, I think, that the overall guidance to all of us is more generous in terms of being allowed to be outside than it was. And that must be seen to be a deliberate policy decision by the government, taking account of the evidence from lockdown 1. They've chosen to make lockdown 2 less onerous in terms of what we can and can't do outside.
There's also an interesting question here, isn't there, about whose best interests you're looking at in that scenario, because the best interests of P, it seems to me, are almost certainly served by going out and having access to the community and exercise. What I suspect care homes are concerned about is P coming back to care home and posing an infection risk to staff and other residents.
Exactly.
But actually, that's not a facet of P's best interests, save insofar that they want the placement to continue to be available to them, and for the staff to remain healthy, and the other residents, I suppose, to an extent, because of the risk then to P. But you're jumping through a number of hoops before you actually get to a risk to P. And really the best interest question has to focus on P.
Well, it does, doesn't it? But then there's two thoughts on that. First of all, P can be assumed to have some degree of altruistic desire, I think, not to infect everyone else. But equally, some of these decisions, I think, are just not best characterized as best interest decisions, and are in fact just either contractual or some other form of restriction on what people can and can't do, where the challenge would be judicial review, probably, or a human rights claim in the county court, rather than a court of protection best interest decision-making process, because actually the decision-making is so multifactorial that it just doesn't properly lend itself to analysis that's based solely on P and their own best interest. So certainly in some cases I've had so far, I've suggested that we needed to go away from the court of protection route in that context, because actually it seemed unlikely there was going to be anything for a COP judge to meaningfully decide, because the government were just saying no, we're not having any visitors because we think it's an infection risk, and we don't, essentially, not in terms, but we don't care what might be in your client's best interests. In that context, it's quite difficult to see how the COP can meaningfully intervene, I think.
I think that's right, and also it risks that sort of nuclear option, doesn't it?
Yeah.
Of the placement saying, well,
notice. Yeah.
We're giving notice, we can't meet the needs of this person because they want to go out 7 times a day, and we can't allow that.
Absolutely. So I see the time, Sian, but there's one more question I think I have to pose us both, which is a really interesting one about the way in which the guidance describes visiting, the care home guidance in particular. So having said it's quite fluid and leaves a lot up to local areas, on one reading at least, it says that all visiting needs to be behind plastic screens and be distanced. And the point's made, well, what about people with dementia, people with sensory impairments? I immediately think about some clients who are deaf-blind, and that is literally pointless then to impose that restriction. What do we think about that, either on a best interest or a human rights basis?
I think I'm going to say the same thing again. It's all a question of fact and degree, taking into account all of the circumstances. For some care homes, the only way they can facilitate visiting may be with plastic screens. For others, that they may well be able to do it in a far less restrictive way. And it has to take account of the needs of the individuals involved. Someone with dementia, actually the most important thing to them might be to be able to touch, to hold hands with a family member, rather than to see them, and actually a short period of touch might give them more benefit than a prolonged period of being in the same room with them. And I think what we do get from the guidance is the sense that all of this is an individualized risk assessment.
Was there anything else you wanted to pick up, Sian, from any of the Q&A points?
No, I think I've covered it all. Thank you. There's some really good questions coming through.
There are, and I'm really sorry that we've stored 106 open questions and haven't been able to answer all of them. I mean, I do stress again that this, more than any other area probably at the moment, is going to be fact sensitive. And I hope the main theme of Sian and my talks has come across, which is the need for careful and individualized risk assessment and decision making, and to move away from blanket rules unless those rules are set out in the legislation, i.e. the regulations that I went to at the start of the talk. I'm sorry, I'll just share it one last time to avoid, well, hopefully make sure we cleared this up. I'm sorry that the paragraph 8 of Regulation 12 wasn't in the forefront of my mind when I opened up. And just to be clear, we do think at the end of all that you can have both a linked household for support role purposes and a linked childcare household for childcare purposes. But that's our best guess at the end of this, what I found to be a very engaging talk. Thanks ever so much, everyone, for coming.
Thanks for all the really good questions that everyone submitted. Thanks for thoroughly testing us. For me, anyway. Steve found it easy.
No, definitely all of us. I'll stop sharing just for the purposes of saying goodbye. The slides, and I think the slides and certainly the recording will be available, Sian's slides and the recording. Thanks ever so much, everyone. We hope it's been useful, and no doubt there'll be more materials coming out from our team at 39 Essex Chambers during the course of the lockdown to try and elucidate various other issues that may come up. Thanks, everyone.
Thank you.